Hello everyone, Dr. Smith, physical therapist here, and today I'm covering the enforceability of non-competes for physical therapists on a state-by-state basis. Before I get into this, please subscribe to the channel, please hit the like button below, share this video if you find it helpful, and please comment as the video moves along. Now I will be going through each state in alphabetical order, trying to put something related to each state on the screen behind me or on the screen somewhere. I'm trying out the green screen today, so hopefully it works out. If not, it will just stay green behind me due to technical difficulties. So let's get right into it. The first state is Alabama, and according to Alabama statute 81190-197, non-competes are unenforceable for physical therapist. So if you're in Alabama and you sign a non-compete, nobody can enforce it due to their statute. The next state is Alaska. In Alaska, they are generally enforceable as long as they are reasonable. Next state is Arizona. In Arizona, they are also generally enforceable as long as they are not broader than necessary to protect a legitimate interest of the employer and are not unreasonably restrictive in both time and scope for the employee. Next state is Arkansas. In Arkansas, non-competes are unenforceable for medical professionals. So if you're a physical therapist and you sign a non-compete in Arkansas, you are exempt from that non-compete. In California, non-competes are unenforceable for anybody, including independent contractors. In Colorado, they are limited in their enforceability. What this means is if the employee has been employed less than 2 years, all they can recover are those training expenses in Colorado. In Connecticut, they are permitted as long as they are reasonable. They will not be enforced if the court rules them unreasonable. Court will look at how much it restricts the employee and how fairly it protects the employer and whether it is against public policy. As a healthcare provider, most of the time, the court is going to look favorably upon you and not enforce these. In Delaware, they are enforceable if they are reasonable with regard to time and geographic scope, and if they protect a legitimate interest. Again, the court will look at the hardship, the restrictions posed on the employee versus the legitimate protection required to the employer. In Florida, they are enforceable if they are reasonable with regard to time and geographic reach, and if they protect a legitimate interest. Again, that will be for the court to decide, but they are enforceable as long as they fit that criteria. In Georgia, non-competes are enforceable, but they must be reasonable and not overbroad. The court will look at public policy and weigh individual concerns of being free to earn versus commercial concerns of the business. In Hawaii, they are generally enforceable unless you are a technology sector worker. So as a physical therapist, they will be enforceable as long as they are reasonable in their time, geographic reach, and scope restrictions. In Idaho, they are enforceable only to key employees and key independent contractors, which are defined as those employees or independent contractors who have gained a high level of inside knowledge, influence, credibility, notoriety, fame, reputation, or public persona as a representative or spokesperson of the employer, and as a result, have the ability to harm or threaten an employer's legitimate business interest. Idaho Code 44270127004. So if you're a physical therapist who hasn't done any of that, then your non-compete is unenforceable in Idaho. In Illinois, they are enforceable, again, as long as they are reasonable in their time, geographic reach, and scope restrictions, not pose too great a hardship on the employee, and not be against public policy. In Indiana, they are enforceable as long as there are restrictions to time, geographic reach, and scope are both reasonable and specific. The court will look at the legitimate interests that need to be protected versus the impact on the employee as well as the public interest. In Iowa, non-competes are generally enforceable as long as the employer needs it to legitimately protect their business. So if it's not legitimately protecting their business, then it is not enforceable. In Kansas, they are generally enforceable as long as the employer is protecting a legitimate business interest and the non-compete does not place a hardship on the employee. As in other states, the restrictions need to be reasonable as to time, geographic reach, and not against the public interest. Kentucky also allows non-competes to be enforced, again, as long as they are reasonable in their restrictions as to scope and purpose. The non-compete does not place a hardship on the employee, and the restrictions, again, are not against the public interest. Louisiana bans a lot of non-competes, and non-competes are only enforceable if they don't last longer than 2 years and are very specific with regard to the geographic restrictions. And it must be in strict compliance with Louisiana Statute 23921. If it is not, it will not be enforced. In Maine, if you're below the poverty level by 400%, non-competes cannot be enforced. As a physical therapist, that's not going to be you. So they can be enforced in Maine, but they must also be reasonable with regard to time, geographic reach, and interest to be protected and not place undue hardship on the employee. In Maryland, non-competes are enforceable if you make over $15 per hour or over $31,000 per year. They are allowed as long as they go along with an employment relationship and restrictions on geographic reach and duration are no broader than necessary to protect the business interests of the employer. They also must not place an undue hardship on the employee or be against public policy. In Massachusetts, non-compete agreements are unenforceable among workers classified as non-exempt under the Fair Labor Standards Act, which is workers paid on an hourly basis, and non-supervisory salaried workers earning under the current salary threshold of $22,000 per year. This will be similar to Maine and Maryland's rule of non-competes being unenforceable for low-income workers, but because you're a physical therapist, you're going to be over this level. And because of that, they are enforceable as long as they are limited with respect to time, geographic reach, and scope. In Michigan, non-competes are enforceable as long as they comply with Michigan Law 445.774, and they can be enforceable as long as they are protecting a legitimate business interest, are not longer than 1 year in time, and are reasonable as to geographic reach, type of employment, and scope. They also must not be harmful to the public. So as a physical therapist, you not being able to provide therapy services would be a harm to the public. So due to that, I believe that it would not be enforceable in Michigan as a physical therapist. In Minnesota, non-competes can be enforceable again if they protect an employer's legitimate business interest and are not broader than that. They also must not place undue hardship on the employee. Same for Mississippi, exact same thing as Minnesota. And for Missouri, so Minnesota, Mississippi, Missouri, the exact same, of it being reasonably necessary to protect an employer's legitimate business interest and reasonable with respect to time and geographic reach restrictions. The employee must not be unreasonably restrained. In Montana, non-competes are only enforceable in situations related to the sale of a business or the dissolution of a partnership. So if you're not being involved in the sale of a business and not being involved in the dissolution of a partnership, then non-competes are not going to be applied to you. Even if you sign one, it cannot be enforced in Montana. In Nebraska, they can be enforceable, but they must not cause undue harsh or oppressive consequences on the employee. For a non-compete to be enforceable in Nevada, according to Nevada Statute 613.195200, non-competes must meet 4 factors to be enforceable. They must, 1, be supported by valuable consideration, 2, not create any restraint on the employee greater than what is required to protect the employer, 3, not place an undue hardship on the employee. And 4, be appropriate in relation to the consideration. Consideration is what the employee receives in exchange for the contract. So, based on this statute alone, I would find it very hard to enforce a non-compete against a physical therapist in Nevada. In New Hampshire, non-competes can be enforced if they are narrowly tailored. And again, that means protecting the public's interest and protecting the employee and the employer, but not being unreasonable. In New Jersey, very similar, as I've stated many times before, it cannot be unreasonable. In New Mexico, non-competes may be enforceable as long as they are reasonable. Again, it has to be reasonable for it to be enforced. So if you're signing anything that's unreasonable, it's not going to be enforced. In New York, they may be enforceable, again, only if they're reasonable and they are not rather than necessary to protect an employer's legitimate interest. And also, again, may not place an undue hardship on the employee and must not be injurious to the public. So if a patient in New York needs physical therapy, but you can't see them because of a non-compete, well, they can't enforce this because then it's injurious to the public. In North Carolina, non-competes must be in writing and as part of an employment contract to be valid. If they are not valid, and again, it has to be reasonable. Non-competes are not permitted in North Dakota, so same as California and Arkansas, they just are not going to be enforced in those states. In Ohio, non-competes may be enforceable in Ohio if they are not more restrictive than necessary in order to protect an employer's legitimate business interest. In Oklahoma, same as California and same as North Dakota and Arkansas, non-competes are not permitted. Now, you may be employed in these states and sign a non-compete, but if you actually check your state statutes, nobody's going to enforce it. In Oregon, non-competes are generally not favored by Oregon courts, but according to statute 653.295, they may be enforced in certain circumstances where the employer can prove the employee has stolen trade secrets and is now using them. You're probably not doing that, so if you are, it may be enforced. But again, even if you did that, the Oregon court is not going to favor non-competes based on their history. In Pennsylvania, non-competes are enforceable as long as they are reasonably necessary to protect the employer's interest. Same thing in Rhode Island, same in South Carolina. Now, South Dakota is a little bit tricky as the non-compete only restricts the former employee from carrying on the same business or profession as the employer. The non-compete also must not last more than 2 years and must be specific with regard to its geographic scope restrictions. Now, because you're already a physical therapist, there's probably some exemptions here. However, I would look into the South Dakota law if you're in South Dakota, just to be safe, because you were already a physical therapist before you were employed by this employer. So I think this is more if you worked for, say, a car dealership and then started your own car dealership. But to be safe, check your state statutes. In Tennessee, they are enforceable as long as the restrictions are reasonable. In Texas, according to statute 15.50-.52, non-competes must go along with an otherwise enforceable agreement. So it has to go with something else. It cannot be enforced by itself. So usually this would be very hard to enforce in Texas, but it depends on what you signed and how crazy your employer is. In Utah, again, it must be reasonable with regard to time, geographic reach, and scope restrictions. In Vermont, they can be enforced, but they must not be unnecessarily restrictive to the employee and should be limited as to their restrictions for time, geographic reach, and the particular industry. In Virginia, they are enforceable as long as they are very narrowly written. In other words, they must not be broader than necessary, and they must protect the interest for the employer, but they also must not hurt the employee. In Washington, non-competes are only enforceable if the employee earns more than $100,000 a year, or the independent contractor earns $250,000 a year from the employer proposing a non-compete. The non-competes are only enforceable as well if it is disclosed prior to or when making the initial employment offer in Washington. So if you didn't know about it, it was never discussed, never signed, it cannot be enforced on you. In West Virginia, they are enforceable if they go along with a legal contract and are not broader than reasonably necessary to protect the business interest. So it can't be standalone. It has to also go with a legal contract. In Wisconsin, according to state statute 103.465, non-competes can be enforceable if they are reasonably necessary to protect an employer and reasonable with regard to their time and geographic reach restrictions. In Wyoming, they are enforceable if they go along with a valid legal agreement. So again, the non-compete itself cannot be enforced unless it is also with a legal agreement. Now, when it comes to what I've seen from people either showing me their non-competes they were given by an employer or employer showing me their non-competes, many times they are not legal contracts in themselves, and usually contracts people sign do not meet the basic criteria for being a legal contract. In the final overview of this video, consideration for a non-compete is required. And what that means overall is that the tide is shifting in many states to generally disfavor non-competes, or at least disfavor non-competes for certain workers, such as low-income workers or healthcare professionals. So realize that there's many states where you may have signed a non-compete already and it's not even enforceable because maybe the state doesn't allow it, or maybe there is no legal contract with it. And some of you may say, well, my employment contract is a legal contract, but if it's an at-will state and either party can terminate the contract at any time, does it really go along with the non-compete? I highly recommend you read your practice acts, just so you make sure you know what's legal in your state as you're practicing, but also read state statutes in regards to employment for healthcare workers. Now, again, many of you have signed these in states where they're not even allowed, or maybe only signed one part of what would make it enforceable, or if you have signed it and your employer has threatened you and you left a job, when you actually look at it from the side of the courts are almost always going to favor you if it was an unreasonable contract or if it creates undue hardship for you. As a medical professional, you need to be able to provide services to the public, and you also need to be able to earn a living. Any non-compete that doesn't allow that will not be favored by the courts. I hope you liked this video. I'm Dr. Smith, physical therapist, and I'll see you guys in the next video. Thank you.